Deborah, I have another tough case that you don't know anything about.
So I should sit back down.
Mr. Weller's sleeping through most of this, but we're gonna wake him up here to do our hearing.
I wondered.
And it's got a lot of money involved and he's not real with it and he's late. And I'd ask if you would stay. I apologize.
Anything to make this.
It's another no lunch Monday. Why don't you go ahead and turn it back on for you now? I would have considered even maybe bumping this, but the complainant is here and he's been waiting for a long time.
All right, guys. Today we are diving into a courtroom case that instantly starts off chaotic. Before the hearing even properly begins, the judge notices the defendant sleeping, arriving late, and acting completely disconnected while a victim sits there waiting for justice after allegedly losing thousands of dollars. What makes this opening powerful is how quickly the courtroom atmosphere shifts from casual to serious, with the judge making it clear he's done allowing delays and excuses in this case.
738 FY, People versus Timothy John Weller. Mr. Weller was charged with a felony computer crime. And as I mentioned, we're returning to the bad old days of multiple remands. This matter was bound over to the circuit court on a felony charge. A large amount of money was taken, $8,000. And it got remanded back to our court for a plea and sentencing. Well, I'm not sure I'm ready to do a plea and sentence, but I would be ready to do a plea. They're remanding these matters back for plea and sentence, but by the nature of the fact that they were a felony and came back as a misdemeanor, they're complicated. I don't know what happened. This case got bound over. There were several status conferences. It was going to be set for trial and it got remanded. And so the remand plea, Mr. Weller, would be to a misdemeanor charge of larceny over $200, but less than $1,000. The original charge was an allegation that you stole $8,000.
Buckle up, guys, because this is where the full weight of the charges finally hits the courtroom. What started as an alleged $8,000 theft suddenly turns into felony computer crimes, habitual offender enhancements, and even the possibility of life in prison. The judge carefully explains how the case bounced between courts before landing back here for a reduced plea deal, but despite the downgrade, you can already tell nobody in that courtroom is treating this like a minor mistake.
Plain old grand larceny, punishable by up to 5 years imprisonment and a fine of up to $10,000. The computer part of it is a allegation that used a computer program, computer system, or computer network to steal more than 1,000, but less than 20,000. That's punishable by up to 7 years imprisonment and a fine of up to $5,000. You're also charged as a habitual felon as a fourth felony offense, making this punishable by up to life in prison. So the matter got bound over to circuit court. The can got kicked down the road a little ways, and then it got remanded back here for a plea to a misdemeanor charge of larceny more than $200, but less than $1,000. Mr. Weller, that's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000 or 3 times the amount of the money taken. In this case, it's alleged to be $8,000. So the prosecutor, and let me confirm this, Ms. Davis, has offered to dismiss the felonies and the supplemental for a plea to larceny over $200. And I understand you inherited this, but thank you for being here.
Quickly looking through the notes, it appears that yes, Prosecutor Marvin had made that offer, larceny 200 to 1,000, and that the restitution was $8,000 joint and several between Weller and Spratt.
All right, guys. Now the courtroom starts unpacking how an alleged felony theft somehow got reduced to a misdemeanor despite the victim losing $8,000. The prosecution confirms restitution is still owed, while the narrator breaks down how the defendant and his co-defendant allegedly pulled off the scheme together. You can feel the frustration building because the victim is still missing his money while the court tries to balance punishment, accountability, and practicality all at once.
All right, Mr. Weller, the allegation is that you're going to be ordered to pay $8,000 restitution, joint and several, with Heather Sproul, one of your co-defendants here. Do you understand?
Yes, sir.
Could you take your hand away from me? Are you going to plead to that misdemeanor charge of larceny over 200 but less than 1,000?
Yes, sir.
Mr. Bush, you confirm that's the plea
Yes,
offer?
it'll be more on an aiding and abetting factual basis, but we have previously discussed that. And this is not a spur of the moment decision today.
All right. Mr. Weller, do you understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Bush is here with you. You can also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
Did you somehow induce the complainant here, Mr. White, to give you $8,000?
No, sir.
Well, tell me what happened.
I was solicited by Miss Heather Sproul to go open an account in my name, and what she did, she stole Mr. Gregory White's phone and transferred the money from his phone into my account. Somehow she got a hold of my account information and transferred the money.
Buckle up, guys, because this section may sound routine at first, but it's actually one of the most important moments in the entire hearing. Judge Middleton slowly walks the defendant through every constitutional right he's about to give up by pleading guilty. Trial rights, witnesses, silence, presumption of innocence, all of it. The calm tone makes the tension even stronger because everyone watching knows the next answers from the defendant could completely change his future.
The only thing I got out of that was like $500. Your Honor.
Well, you must have known there was some nefarious purpose for you to just blankly open an
She
account.
told me that, Your Honor, not to cut you off, but she told me that she inherited the money from her uncle. So I went and opened the account, and she went and, like I said, stole Mr. White's phone and transferred it. That's how she got his information. That's
All
from
right,
that
but
phone.
then you withdrew $8,000 from the Omni
That's
Bank.
because I believed her that she inherited that money, Your Honor. If I had known that, like I told Mr. Gregory White, if I had known it was his money, I would never have done it in the first place.
Timothy stated Heather gave you $3,600 and she kept the rest.
No, that's not true.
Now that's what the police say.
He must have misunderstood what I was trying to tell him.
All right. Well, you
May
didn't
I
just,
inquire on it?
yes.
And Mr. Owen, we've talked about this, and in retrospect, you realized that it was kind of a hinky thing that
Yeah.
that money was there for just a couple hours and you were paid either their theory, multiple thousands or $500.
I still can't take responsibility for it, Your Honor. But
All right. So you knew this wasn't all on the up and up.
right, Your Honor.
And he's open to his share of restitution. I suggest to the court that he wasn't as sophisticated as the other individual to put this together.
He's also not as dumb as he presents here. He knows more than.
All right, guys, this is where the defendant finally starts explaining his side, and honestly, the story immediately raises red flags everywhere. He claims he believed the money came from an inheritance, yet somehow thousands of dollars ended up flowing through his account before casino gambling entered the conversation. The judge clearly isn't buying the explanation, and you can almost feel the courtroom losing patience as the excuses become harder and harder to believe.
For sentencing on a certain date. Let's see if we can line these up, save the complainant. Well, that can't be right. set for sentencing on September 5th. So let's see how I look for September 5th at 10:30. It's next Tuesday. I can do it. All right, I'll accept your plea at 10:30. I'm not sure how we're gonna do this. Let's say it. Mr. Wilson?
Yes, Your Honor, if I please the court, I provided transportation for Mr. White because quite frankly, he has none. And I will not be able to do so during the month of September.
Well, the other case is already set for September 5th. Mr. White, I can give you a bus pass to get here and back on September 5th. So I'll give you a round trip bus passes for that morning. But you're gonna need to be here for Ms. Sproul anyway. So here's 2 round trip bus passes for you to get here on September 5th. Courtesy of generous people that watch this channel.
Buckle up, guys, because Judge Middleton completely shifts gears here and starts pressing the defendant hard about accountability. Instead of focusing on excuses, the judge focuses on responsibility, asking why someone wouldn't voluntarily pay back every single dollar stolen. The courtroom tension rises as the defendant struggles to explain himself, while the judge makes it crystal clear that being less involved than a co-defendant still doesn't erase participation in the scheme.
Thank you, Your Honor. What time are?
I'm gonna set this for 11. The other one's at 10:30. Now, you called this morning, you were out of state or you had to be somewhere. How'd you get here today?
My cousin brought me all the way back.
All right, how'd you get here to the courthouse?
My cousin drove up here.
Where's he?
He took off. Yeah, I'm supposed to let him know I'm supposed to get a hold of him because he has no phone now.
Hi, could you guys check and see if Mr. Weller drove here today? Yes, thanks. Bye. You've got a terrible driving record.
Yeah,
You keep-
they'll see me getting, Your Honor, I have to cut you off again, but they'll see me getting out of a passenger seat of a maroon or burgundy colored Dodge
All right.
and passenger side.
Now, in the
It was in this parking
report,
lot out
you're
here.
talking about driving. The other thing I need to confirm, I don't know whether that interview was recorded. According to the affidavit of probable cause, she gave you $3,600, which you took to Firekeepers and lost, except for $23. Plus, you were driving all over the place.
I learned my lesson from
I
that,
made
Your
a
Honor.
traffic stop bearing a Michigan temporary plate, made contact with Timothy Weller in the driver's seat. I don't know what I'd do to keep you from driving. So there's a dispute about how much money you took. You don't have 2 nickels to rub together. I'm not very encouraged about this man getting his $8,000 back. But you agree that the restitution will be 8,000 joint and several with Miss
I'm willing,
Sproul?
like I said, I'm willing to make this right with him. I feel bad.
All right, guys, this part completely changes the tone of the hearing for a moment and reminds everyone who the real victim is here. After hearing the complainant has trouble getting transportation back to court, Judge Middleton personally provides bus passes funded by supporters of the channel. It's a small gesture, but it says a lot. While the defendant sits facing consequences, the judge makes sure the victim still has access to the justice system without extra hardship.
And I do want to, I have not looked at this carefully, obviously. So in just going over the bank statement that I pulled up, there may be some withdrawal fees and that sort of thing. So
Okay.
I guess I would like to leave that restitution somewhat open. I mean, it's expected it's going to be around the $8,000, but there may be some fees. I want to get that cleared up so that the victim is made right. But I also have concerns about Mr. Weller's ability to be here himself on Tuesday. And if we have the victim coming back and the other co-defendant, I want to make sure that he is going to be here as well. So I guess I'll leave that to the court's discretion as far as that goes.
I'm willing to come back.
All right, yes, your bonds.
Buckle up, guys, because the hearing suddenly turns investigative again when the judge starts questioning how the defendant even made it to court. The answers become shaky, details stop adding up, and concerns about driving violations quickly enter the conversation. Then the courtroom circles back to the casino allegations and missing money, creating even more doubt about the defendant's honesty. At this point, you can tell the judge's patience is running dangerously low.
We'll deal with it. That's next Tuesday, which is 8 days. Stealing $8,000 from this guy certainly develops at least 8 days. Plus you keep driving a damn car.
No, I think he's been in jail for upwards of 45 days in this case.
Yeah, he bonded out. I'm not sure how. And I set the bond at the amount that was stolen. I think it got reduced when it was remanded. And I don't like these remands, and there's not much I can do about it, but they come in, they're always difficult to deal with. Yes, your bond's canceled. You're no longer presumed to be not guilty. I will see you next Tuesday at 11 o'clock.
Thank you, Your Honor.
What am I going to deal for?
Your bond's canceled.
Why is my bond?
All right, guys, this is the moment where the courtroom starts realizing the victim may never fully recover the stolen money. The defendant says he wants to make things right, but nobody seems convinced there's an actual plan behind those words. Prosecutors raise concerns about whether he'll even return to court, and then everything changes instantly when the judge decides to cancel his bond. The mood in the room shifts fast once custody becomes a real possibility.
Yeah.
Plus you showed up late and slept through most of the earlier proceedings. I'm not sure what's going on with you, but I hope you're in a better state of mind when I see you next Tuesday morning. All right, you're free to go.
Thank you, Your Honor.
Why am I being arrested for? I don't understand. I'm almost all my plea then.
Oh, it's too late for that. We can
Man,
discuss
why am I
that
being
next
arrested for, man? I ain't
You're
doing anything
being,
wrong,
you're not
man.
arrested. You pled guilty to stealing $8,000 with.
Buckle up, guys, because this final courtroom exchange delivers the strongest reality check of the entire case. After pleading guilty, the defendant appears confused about why his bond is being revoked, but Judge Middleton wastes no time explaining that the presumption of innocence disappears once guilt is admitted in open court. The judge also calls out the lateness, sleeping in court, and overall behavior before deputies prepare to take him away, ending the hearing on a brutal note.